This is part 7 of property. Ended last time talking about land sale contract and performance of the land sale contract and defects. Looking at performance of the land sale contract, the implied warranty of habitability. This applies to new construction. Minority of jurisdictions apply this to repairs and or remodels. You must deliver an implied warranty of habitability. Remedies for breach of the land sale contract is damages. This is the difference between the contract price and the fair market value at time of sale. Specific performance may be available for a purchase of land due to the unique nature of land. So if the seller breaches sale of land, the buyer may force sale of the land through specific performance due to the nature of land. Land sale contract and equitable conversion. This is during the pendency of a land sale contract, equitable title passes to the buyer. The seller effectively holds property in trust for the buyer. There's a duty of the seller to keep up the property. The risk of loss falls on the buyer unless it's intentional and or negligent act by the seller. Security interest in real property. Mortgage is a mortgage in a lien theory, which is the majority of jurisdictions. The mortgagee, meaning the bank, is treated as a lien holder. This does not sever a joint tenancy. We discussed that earlier. Transfer of transfer by the mortgagor to a transferee, to a third party. Here, the transferee is primarily liable. The mortgagor is secondarily liable. It's the borrower. This includes situations of assumption, unless the transferee takes title subject to the mortgage, then the transferee is not liable. Now there is an exception where the transferee is primary liable, the mortgagor is secondary liable. It's an exception where the mortgagee modifies the mortgage after transfer. This releases the original mortgagor. And at foreclosure, under lien theory, a mortgagor has a right to possess until foreclosure. They are considered the owner. Under foreclosure, priority interests, a purchase money mortgage has priority over all other priorities, even those recorded earlier. Where the modified mortgage, where the mortgage has been modified, the modified aspect is subordinated to other mortgages that existed at the time of the modification. Delivery and recording of deed. There's a recording act. This is found in all states. This is in contradiction to the common law first in time, first in right. So all states have enacted a recording act. The recording act may be a notice statute or it might be a race statute. Notice statutes, the majority of jurisdictions here, you need only purchase without notice of a prior interest to prevail, meaning a good faith purchaser need not record to prevail over a prior interest, but must record to prevail against a subsequent interest. On a race statute, there's a minority of jurisdiction. This is kind of like the first in time, first in right, but it's the first to record wins. When disputes about the use of land, here we have easements and covenants. We're going to conclude this section with easements. An easement is a right of one party to make specific limited use of land owned by another. This is a servient estate is subject to the easement. The dominant estate benefits from the easement. You have an express easements may be formed by express agreement. There's an agreement of the parties, must comply with the statute of frauds. You have an easement by necessity that is created when one property is virtually useless without the easement. Here both must have been under common ownership in the past, and necessity must have arisen at the time the property was severed into two separate estates, or the two estates were created. You have easement by prescription. This is obtained by use. This is similar to adverse possession, such as open, notorious. But it need not be exclusive. An example here would be the public easement for beach access. You have a negative easement. This is a restrictive covenant, also known as a restrictive covenant. This prevents a landowner from using land in particular ways. It must be expressly created It's generally only allowed for use of light, air, support, or stream water from artificial flow. Termination of easements, they can be terminated with a writing expressly terminated, must comply with the statute of frauds. It can be terminated where the owner of the easement acquires title to the underlying estate, so one owner owns all of the estates, essentially negates the necessity of the easement. May be terminated by an attempt to convey only the easement separate from the land it benefits, then it terminates that easement. There is sale to a bona fide purchaser, where a bona fide purchaser doesn't know of the easement and it hasn't been recorded. That terminates the easement. Profits, an easement for profits. This is an easement to enter and remove specific natural resources. Could be game. Here you have an exclusive profits easement. This is unlimited exclusive right to take the subject matter from the lands. You can take as much as you want. Non-exclusive profits easement. This is the majority of jurisdictions. The right to profits is limited by quantity, time, or use, or that is shared. And that completes part 7 of property.